In September 2025, the U.S. Senator Ted Cruz stood before the U.S. Senate and introduced a bill called the Nigeria Religious Freedom Accountability Act of 2025. His words were not diplomatic. They were not the careful language of a foreign policy committee managing a bilateral relationship. They were an indictment. He said, Nigerian Christians are being targeted and executed for their faith by Islamist terrorist groups and are being forced to submit to Sharia law and blasphemy laws across Nigeria. It is long past time to impose real costs on Nigerian officials who facilitate these activities. 1 month later, President Donald Trump announced that the United States had designated Nigeria a country of particular concern, the most serious label the U.S. government assigns to countries engaging in widespread and egregious violations of religious freedom. The same designation Nigeria received in December 2020 and which the Biden administration quietly removed in November 2021. Trump did not stop at designation. He directed the Department of Defense to prepare for possible military action in Nigeria. His Defense Secretary Pete Hegseth confirmed the preparations with language that no American official had used about Nigeria in the country's 65 years of independence. He said, if Nigeria does not protect its Christians, the U.S. will kill the Islamic terrorists involved. The Nigerian government's response to all of this, from Tinubu's presidency, from the information minister, from senior officials across the administration, was a categorical denial. President Tinubu said in September 2025 that claims of religious persecution in Nigeria are a lie from the pit of hell. His information minister called them false, baseless, despicable, and divisive. Now hold both of those realities simultaneously. An American president threatening military action against Nigeria over the killing of Christians. A Nigerian president calling that framing a lie from the pit of hell. And in the middle of that international confrontation, Nigerian pastors, Christian leaders, and legal advocates launching a domestic organization called CLAIR, Christian Legality Against Islamic Rascality, as a formal legal and institutional response to what they describe as the rascality of Islamic legal overreach into the lives of citizens whose constitutional rights guarantee them protection from exactly what the Sharia courts have been doing to them for 25 years. The question this investigation is going to answer is not whether CLAIR is right or wrong in its characterization of what is happening to Nigerian Christians. The question is what CLAIR's emergence in the specific context of Trump's designation, Cruz's bill, the inter-society data, the Tinubu denial, and 25 years of documented Sharia court outcomes reveals about where Nigeria actually is as a country. About what happens when domestic legal mobilization and international political pressure arrive at the same historical moment. And whether the Nigerian federal government can continue to deny the existence of a crisis that is simultaneously being documented by its own citizens' organizations, condemned by the United States Congress, and designated as a country of particular concern by the world's most powerful government. Before we go further, if you're new here, this channel exists for one reason: to give Nigerians the political analysis mainstream media is too afraid or too compromised to deliver. Hit subscribe and stay with me. This gets deeper. Let me establish the documented factual landscape first, because this investigation requires a precise evidence-based foundation, and the data available as at April 2026 is more extensive and more serious than any mainstream Nigerian media outlet has presented in full. The International Society for Civil Liberties and the Rule of Law, Inter-Society, is a Nigerian-based NGO whose data methodology has been described as globally respected for accuracy by multiple international monitoring bodies. Their August 2025 report documented that at least 7,807 Christians were massacred across Nigeria in the first 220 days of 2025 alone. That is a daily average of 32 Christians killed per day. Nearly 8,000 people were reported kidnapped on account of their Christian faith in the same period. Their cumulative data covering the period from 2010 to October 2025 documents at least 185,000 people killed on account of their faith in Nigeria, including 125,000 Christians and 60,000 individuals described as non-violent Muslims. 19,100 Christian churches have been burnt to the ground. Over 1,100 Christian communities have been seized and occupied by jihadist forces. 20,000 square miles of land belonging to largely Christian communities have been annexed. Over 600 Christian clerics, among them 250 Catholic priests and 350 pastors, have been abducted, with dozens subsequently killed. The Armed Conflict Location and Event Data Project, CLAIR, a US-based crisis monitoring organization, provides a different set of numbers. Its data as at 2025 shows just under 53,000 civilians, comprising both Muslims and Christians, killed in targeted political violence since 2009. CLAIR's senior Africa analyst has noted that claims of 100,000 Christians killed since 2009 are not supported by available data, and has identified the causes of violence as including conflicts over political power, land disputes, ethnicity, cult affiliation, and banditry alongside religious motivation. Both datasets are cited in this investigation because the analytical standard this channel applies requires presenting the full evidentiary picture, including the contested data, rather than selecting the numbers that support a predetermined conclusion. The difference between Inter-Society's 125,000 and CLAIR's 53,000 total is real, significant, and methodologically explained by different definitions of religious motivation and different data collection methodologies. Both datasets point in the same direction: massive, sustained, catastrophic violence against civilian populations in northern and middle belt Nigeria, with Christian communities disproportionately represented among the victims. Now place this data in the legal context that CLAIR is responding to, because the violence and the legal apparatus are not separate phenomena, they are connected. Nigeria remains one of only 7 countries in the world where blasphemy is punishable by death. In 12 northern states, Sharia-based criminal codes mandate execution for alleged insults to Islam. As this channel documented in the WhatsApp death sentence investigation, Yahya Sharif Aminu was sentenced to death in Kano in 2020 for sharing a song. As of the most recent available reporting, the Nigerian Supreme Court is currently reviewing his case, the first time the apex court has been forced to engage, however tangentially, with the constitutional validity of Sharia blasphemy provisions. That review, if it produces a ruling, would be the most significant legal development in the Sharia constitutional crisis since 1999. In 2023 alone, at least 31 people were arrested on blasphemy charges in Kano, Sokoto, and Bauchi states. Most remained in prolonged detention without fair trial. Mob violence continued to claim victims. In Bauchi, a young man accused of insulting Islam during an argument was burned publicly while police stood by. In October 2025, a pastor in Rachas village in Plateau State warned the Nigerian army of an imminent Fulani offensive. The army publicly condemned him for disseminating fake news and accused him of stoking division. The following day, at least a dozen Christians were killed in exactly the attack he had warned about.
The army's response to a pastor's security intelligence was to attack the pastor, not to defend the community. This is the environment in which CLAIR was launched, not as a reaction to an abstract theological debate, as a direct legal and institutional response to a 20-year accumulation of documented evidence that the Nigerian state's security, judicial, and constitutional machinery has been applied against Christian communities in ways that the constitution that governs all of them explicitly prohibits. Now, examine what CLAIR represents institutionally, because the name itself is an analytical statement that requires unpacking. Christian Legality Against Islamic Rascality. Each word in that name is a deliberate choice. Christian legality signals that the response being mounted is legal, not violent, not secessionist, not purely ecclesiastical. It is a claim to the legal framework of the Nigerian state as the instrument of protection. It is an assertion that Nigerian Christians have constitutional rights that are being violated by identifiable legal mechanisms, and that the appropriate response is to use the law, Nigerian courts, Nigerian constitutional provisions to challenge those violations. Against Islamic Rascality is the most contested element of the name and the one that requires the most analytical precision. This channel applies a consistent standard. Examine what the phrase is actually describing, not what its most inflammatory interpretation would suggest. Rascality in this context is being used to describe specific documented behaviors: the blasphemy prosecutions, the Hizbah enforcement against Christians in shared public spaces, the Sharia courts claiming jurisdiction over matters that the Constitution places outside their competence, the bounties placed on pastors for alleged religious speech. These are documented, named, and verifiable institutional actions. CLAIR is not a theological verdict on Islam. It is a legal characterization of specific institutional behaviors that its founders argue are constitutionally impermissible. Whether that characterization is analytically precise is a legitimate question. This investigation raises it directly, because the word rascality carries an emotional charge that creates a political risk for the legal strategy CLAIR is attempting to mount. A legal organization whose name characterizes the opposite party as engaging in rascality has preframed itself as a partisan rather than a constitutional actor. And in Nigerian courts, in Nigerian political discourse, and in the international diplomatic conversations that now surround this issue, the credibility of a legal argument is partly determined by the neutrality of its presentation. The strongest legal challenges to Sharia's constitutional validity, and there are strong ones as this investigation has documented across multiple investigations, are the ones that argue from constitutional text, from the rights of all citizens, and from the equal protection principle. They are the ones that say the Constitution does not permit this, and here is the specific provision that prohibits it. They are not the ones that characterize the opposite party in terms that can be dismissed as religious prejudice. CLAIR's founders understand the legal landscape they are entering. The question is whether the name they have chosen for their organization, which will be the first thing every judge, every political actor, and every international observer sees, serves or undermines the constitutional arguments they intend to make. This is not a criticism of their motivation. It is an observation about legal strategy. And legal strategy is what CLAIR needs to get right, because the constitutional arguments available to it are powerful. And wasting them on framing battles would be a disservice to the communities whose protection those arguments are designed to secure.
Now, examine the specific constitutional arguments that CLAIR and any serious legal challenge to Sharia's reach can make, because these are the arguments that the Nigerian Supreme Court has been avoiding for 25 years, and that the current international pressure may finally create the political conditions for it to hear. Section 10 of the 1999 Constitution, no government of the Federation or of a state shall adopt any religion as state religion. 12 state governments have done exactly that, not secretly, publicly, for 25 years, without a Supreme Court ruling on the constitutional validity of what they have done.
Section 38. Every person is entitled to freedom of thought, conscience, and religion. Criminal Sharia applies to Muslims by birth in the 12 states whether they practice or not. A person who does not practice Islam, who holds a nominal Muslim identity by birth, is subject to capital punishment for speech under Sharia provisions without any voluntary adoption of the religious framework that prescribes that punishment. Their Section 38 rights have never been litigated against that reality. Section 49. Every citizen of Nigeria shall have equality of rights, obligations, and opportunities before the law. The evidentiary asymmetry in Sharia adultery cases, where a pregnancy convicts a woman while the four-witness standard acquits the man in the same case, is a textbook Section 42 violation. It has never been formally litigated on equality grounds in the Nigerian Supreme Court. Section 33. Every person has a right to life. A public bounty on a named pastor for alleged blasphemy, documented in a previous investigation on this channel, is a threat to life. The DSS silence on that bounty is a failure of the constitutional protection that Section 33 requires the state to provide. These 5 constitutional provisions are CLAIR's legal arsenal. They are not novel arguments. They are the arguments that Warapa made in the Safia Hussaini and Amina Lawal cases. They are the arguments that every serious constitutional scholar who has examined the Sharia question has identified as the strongest available. What has been missing is not the argument. What has been missing is the institutional will at the Supreme Court level, at the federal government level, at the Attorney General level to make the argument formally, force a ruling, and enforce the outcome. The question CLAIR's launch forces into the open is whether the current political environment, Trump's CPC designation, Cruz's bill, the threat of U.S. sanctions against individual Nigerian officials who facilitate religious violence or enforce Sharia blasphemy laws, the international diplomatic pressure mounting from the U.S. Congress, the European Parliament, the UN, and the ECOWAS Court of Justice creates the political conditions under which that institutional will finally becomes available.
Now examine the international dimension, because the convergence of CLAIR's domestic legal mobilization with the most significant international pressure Nigeria has faced in its post-independence is not coincidental. And understanding both together produces an analytical picture that neither alone provides. President Trump's October 2025 designation of Nigeria as a country of particular concern was not a surprise to anyone who had been tracking the legislative momentum in Washington since January 2025. Senator Cruz's Nigeria Religious Freedom Accountability Act, House Resolution 866 condemning the persecution of Christians in Nigeria and standing ready to support Trump in taking decisive action, the joint briefing between the House Appropriations Committee and the House Foreign Affairs Committee following Trump's October 31st directive to investigate the slaughter of Christians in Nigeria. The testimony of Catholic Bishop Wilfred Anagbe before the U.S. House Subcommittee on Africa in March 2025, describing the experience of Christians in Nigeria as a church under Islamist extermination, and the subsequent Fulani militia attack on his own home village that massacred 12 of his relatives. The Nigeria Religious Freedom Accountability Act specifically proposes sanctions against Nigerian officials who enforce Sharia and blasphemy laws, not who permit violence generally, specifically against officials who enforce the legal mechanisms that CLAIR is challenging domestically. The domestic legal strategy and the international sanctions pressure are targeting the same institutional mechanisms from 2 different directions simultaneously. The Tinubu government's response to the U.S. pressure has been denial and counter-accusation. Tinubu's statement that claims of religious persecution is a lie from the pit of hell was not a measured diplomatic response to a complex international situation. It was a political statement designed for a domestic audience, specifically for the Northern Muslim political coalition whose support his government requires and who experience the international Christian persecution narrative as an attack on their own religious community and national dignity. That domestic political calculation is understandable in its own terms, but it has a specific cost. Every denial issued by the Tinubu government in response to documented evidence, the inter-society data, the bishop's testimony, the congressional record, is a denial that the international community is watching in real time. And the gap between what the Nigerian government denies and what the international documentation shows is the gap that the Cruz bill's sanctions provisions are designed to close. The specific mechanism that makes this convergence most consequential is the sanctions threat against individual Nigerian officials. Unlike country-level sanctions, which affect all Nigerians regardless of their individual responsibility, targeted sanctions against individual officials create personal, financial, and travel consequences for the specific people who make the decisions that produce the outcomes being sanctioned. A Sharia court judge who sentences a man to death for a WhatsApp message, a DSS director who maintains silence on a public bounty placed on a pastor, a state governor who refuses to domesticate the Child Rights Act. These are the individuals whom the Cruz bill threatens with travel bans and asset freezes. Personal consequences for individual decisions is a different kind of pressure than country-level diplomatic censure. It is the kind of pressure that changes individual behavior rather than producing collective denials. And it is arriving at exactly the moment when CLAIR is attempting to build a domestic legal record against the same individuals and the same decisions.
Now, examine the Tinubu administration's position with the analytical precision the situation demands, because the government's handling of this crisis has been one of the most consequential governance failures of 2025, and its consequences extend beyond the religious freedom question. Tinubu said in September 2025 that there is no religious persecution in Nigeria. That statement was made while the inter-society data was in the public domain, while the congressional record of testimony from Nigerian Christians was in the public domain, while the October 14th Rachas village massacre, predicted by a pastor whose warning the army dismissed as fake news, confirmed by the killings that followed the next day, was in the public domain. The specific act of denying documented evidence in public, not questioning its methodology, not providing alternative data, not acknowledging partial validity while contesting specific claims, is not a diplomatic strategy. It is a credibility destruction exercise. And the international response to that destruction of credibility has been documented and escalating. The Trump CPC designation came after Tinubu's denial. The Congressional Investigation Directive came after Tinubu's denial. The European Parliament condemnations came in the context of continued Nigerian government denial. The UN's repeated condemnations of Sharia blasphemy laws have been met with continued Nigerian government denial. The denial strategy is not working. It is producing the opposite of its intended effect. Every denial in the face of documented evidence does not reduce international pressure. It increases it because it confirms to every international actor watching that the Nigerian government does not intend to address the crisis voluntarily, and that external pressure must therefore be intensified to produce any change. The domestic political calculation that drives the denial, the need to maintain the Northern Muslim coalition's confidence that Tinubu is not capitulating to what they experience as a Western anti-Islam campaign, is real and has real political cost attached to any change. But the calculation has a horizon problem. The international pressure is not going to reduce while the documented violence continues at its current scale. The Cruz bill's sanctions provisions are advancing through the U.S. legislative process. The CPC designation has been made. Trump has threatened military action. The trajectory of that external pressure, absent a genuine domestic policy change, is towards outcomes that are far more damaging to Nigeria's international standing and its bilateral relationships than the political cost of acknowledging the crisis would have been. This is the governance failure at the center of the Tinubu administration's handling of this issue, not the violence itself, which predates his government and is partly beyond any administration's immediate control, but the calculation that denial is a sustainable political strategy in the face of documented evidence and mounting international consequence. It is not sustainable, and the longer it continues, the more it costs in diplomatic capital, in aid relationships, in the bilateral security cooperation that Nigeria needs to address the ISWAP insurgency that itself is a primary driver of the violence.
Now, address the counter-arguments with the intellectual honesty they require, because this investigation applies the same standard of fair engagement to arguments it disagrees with that it applies to every other analytical question. The strongest counter-argument to the Christian persecution framing, and it is made by serious analysts, by ACLED, and by people with direct knowledge of the Nigerian conflict, is the complexity argument. The violence in northern Nigeria and the Middle Belt is not a simple religious war of Muslims against Christians. It is a multi-causal conflict involving land competition, ethnic rivalry, banditry, climate-driven resource pressure, state failure, political manipulation of religious identity for electoral purposes, and jihadist ideology simultaneously. Describing it primarily as Christian persecution flattens a complex reality into a narrative that serves specific political interests in Washington, in Nigerian Christian communities seeking international support, and in the U.S. evangelical networks that have been the primary drivers of the congressional pressure. This argument is analytically important and must be taken seriously. ACLED's data showing that the majority of jihadist victims are Muslims is real. The land competition dimension of the Fulani herdsman crisis is real. The banditry dimension is real. The political manipulation of religious identity for electoral purposes is real. The response is also analytically precise. Acknowledging complexity does not reduce the documented reality of disproportionate violence against Christian communities, the documented operation of Sharia laws that carry death sentences for speech, the documented bounties placed on pastors, the documented burning of churches, the documented imprisonment of Christians in Sharia courts for activities that federal constitutional law protects. A complex conflict can simultaneously have multiple causes and still produce specifically religious targeting that deserves specific legal and political response. Complexity is an explanation. It is not a justification, and it does not make the constitutional violations documented across this series any less real or any less demanding of legal remedy. The second counter-argument is the sovereignty argument. The U.S. designation of Nigeria as a country of particular concern, the Cruz bill's sanctions provisions, Trump's threat of military action, these are interventions in Nigerian sovereign affairs that Nigerians of all religious backgrounds should find alarming, regardless of their position on the religious freedom question. This argument is correct and important. Nigerian sovereignty is not a rhetorical position. It is a constitutional principle and a national interest that every Nigerian, regardless of religion or region, has a stake in protecting. The problem is that sovereign governments protect their sovereignty from external pressure by resolving the domestic conditions that create the invitation for that pressure. Nigeria's government has not resolved those conditions. It has denied their existence. And a government that denies documented violations of its own citizens' constitutional rights does not have a strong sovereignty argument against the international community's response to those violations. Sovereignty requires accountability. The Nigerian government's accountability deficit on this crisis is the vulnerability that external pressure is exploiting. The third counter-argument, the one that will come most forcefully from within the northern Nigerian political and Islamic establishment, is that CLAIR's name, its framing, and the international Christian advocacy ecosystem it is connected to are themselves provocations that escalate rather than reduce religious tension in Nigeria. That organizations that characterize Islamic legal practice as rascalism and that invite U.S. sanctions against Nigerian officials are not seeking constitutional protection. They are seeking to delegitimize Islamic governance in Nigeria using Western political pressure as their instrument. This argument has political weight and cannot be dismissed. The International Christian Advocacy Network that has been building the Washington pressure, Open Doors, Alliance Defense Freedom International, Inter-Society, the Vatican, is not neutral. It has specific interests and specific theological commitments that shape how it presents the Nigerian crisis. The framing of the crisis as Christian genocide, as Islamist extermination, as a campaign to eradicate Christianity from Nigeria, these are framings that serve specific advocacy purposes and that are contested by data analysts like CLAIR, who have examined the same violence with different methodologies. But the response to advocacy framing cannot be to deny the documented evidence it is presenting. The appropriate response is to address the documented constitutional violations on their own terms. The Sharia death sentences, the blasphemy laws, the evidentiary asymmetries, the HISPA enforcement, through domestic constitutional remedies rather than allowing the crisis to remain in the international political arena where Nigeria's sovereignty is most vulnerable. Drop a comment right now. Before the strategic outlook, if the Nigerian Supreme Court issues a landmark ruling this year declaring Sharia blasphemy laws unconstitutional under Section 39, do you believe the Tinubu government would enforce that ruling in all 12 Sharia states? One answer. Tell me below. Now look at the reform dimension, because the most important actors in this story are not Trump, not Cruz, not Tinubu, and not the Sultan. They are the Nigerian lawyers, activists, and constitutional scholars who have been fighting this battle inside Nigerian courts with Nigerian law for 25 years and who are still fighting it. WAPA, the Women's Rights Advancement and Protection Alternative, litigated Safia Hussaini and Amina Lawal before any U.S. senator took notice of Nigeria's Sharia crisis. Their legal strategy, arguing from within Islamic jurisprudence that the evidentiary standard had been incorrectly applied, combined with constitutional arguments about equal protection, saved 2 women from death sentences without requiring a foreign government to threaten military intervention. The Humanist Association of Nigeria has represented blasphemy defendants, including Mubarak Bala, held without trial for 2 years for social media posts, and has built a documented legal record of Sharia court constitutional violations that is available to any lawyer or court willing to use it.
The Alliance Defending Freedom International, working with local Nigerian allied lawyers, has represented Christians imprisoned in Sharia courts, Christian converts facing violence, and Christian ministries targeted for their activities. Their casework has produced the first-hand testimony that is now being presented to the U.S. Congress. These organizations, domestic and internationally supported, represent the reform tradition that this channel has consistently identified as the most powerful available. They are working inside the Nigerian legal system, using Nigerian constitutional law, building a record that Nigerian courts and eventually the Nigerian Supreme Court will have to address. CLAIR's emergence adds a new organizational voice to that tradition. The question is whether it adds legal precision or political noise, and that question will be answered by the quality of the constitutional arguments it brings to court, not by the emotional resonance of its name. Where does this go from here, and what should Nigerians be watching with specific attention as of April 2026? The most consequential near-term indicator is the Nigerian Supreme Court's handling of the Yahaya Sharif Aminu case. The court is currently reviewing a death sentence for a WhatsApp message. Whether it issues a ruling on the Section 39 constitutional question, freedom of expression, or uses procedural avoidance to release him without ruling on the underlying law will be the clearest available signal of whether the international and domestic pressure of 2025 has created new conditions for judicial engagement with the Sharia constitutional question. Watch for any movement on the Cruz bill in the U.S. Senate. As of April 2026, the Nigeria Religious Freedom Accountability Act has been introduced. Whether it advances through committee, whether it gains all sponsors, whether it reaches a floor vote, each of these steps increases the specific threat of individual sanctions against named Nigerian officials. The moment a Nigerian state governor, a Sharia court judge, or a federal official is named in a sanctions filing, the political calculation around the Sharia constitutional question in Nigeria changes overnight. Watch for CLAIR's first formal legal filing. An organization is only as powerful as its first court document. The quality of the constitutional arguments CLAIR brings to its first case, the specific provisions cited, the specific violations documented, the specific remedies sought will determine whether it is a serious legal actor in the constitutional landscape or a political organization that uses legal language. That distinction will be visible in its first filing. Watch for Tinubu's next public statement on religious freedom in Nigeria. His September 2025 denial, a lie from the pit of hell, has become an internationally documented statement that is cited in the U.S. congressional record. Any modification of that position, any acknowledgement of the scale of the violence, any announcement of specific accountability measures would represent a genuine policy shift whose implications for the Sharia constitutional question and for the international pressure would be immediate. Watch for whether any northern Nigerian governor uses the international pressure as political cover to distance himself from the Sharia enforcement architecture that CLAIR is challenging. The pattern documented across this series shows that northern governors have consistently avoided any public engagement with Sharia reform. But the Cruz bill's personal sanctions provisions create a new calculation. A governor who facilitates Sharia blasphemy law enforcement is now a governor who may face personal travel bans and asset freezes. That personal consequence changes the incentive structure in ways that no amount of domestic political pressure has previously been able to change.
Here is the answer to the question this investigation opened with. Nigerian pastors have launched CLAIR, Christian Legality Against Islamic Rascality, at the specific moment when the international pressure on Nigeria's Sharia constitutional crisis has reached its most intense point since 1999. The Trump's country of particular concern designation, the Cruz sanctions bill, the congressional investigation into the slaughter of Christians in Nigeria, the ECOWAS court's findings, the UN's condemnations, Pope Leo XIII's prayer for the over 200 Christians massacred in Benue in June 2025. All of this international pressure is targeting the same institutional mechanisms: the Sharia blasphemy laws, the Hizbah enforcement, the Sharia court's criminal jurisdiction, that this channel has been investigating across this entire series since the first investigation into the 12 states that created a country within Nigeria. The convergence is not coincidental. It is the accumulated consequence of 25 years of documented constitutional violations, 25 years of federal institutional silence, 25 years of the same procedural escape valve being used to manage individual cases without ever addressing the constitutional architecture that produces them. CLAIR's emergence represents something that has not previously existed in Nigeria's Sharia constitutional crisis, a formally organized domestic legal challenge that is constitutionally grounded, institutionally structured, and operating in a political environment where the international pressure has finally created the conditions under which a Nigerian Supreme Court ruling on the constitutional validity of Sharia criminal law might be politically possible to obtain and politically possible to enforce. Whether CLAIR delivers on that possibility depends on the quality of its legal arguments, the courage of the courts it brings those arguments before, and the willingness of a Nigerian federal government to choose constitutional clarity over political convenience for the first time in 25 years. The Nigerian Christian communities, the farmers in Benue who cannot reach their fields, the women in Kano whose blasphemy accusations are processed without constitutional protection, the pastors in Plateau whose security warnings are called fake news by the army they're supposed to trust, they have been waiting for that choice for 25 years. CLAIR is the latest, most organized, most internationally contextualized attempt to force it. The Constitution is on its side. The question is whether Nigeria's institutions are. Here is my question for the comments. The Nigerian Supreme Court is currently reviewing the Yahaya Sharif Aminu case, a death sentence for a WhatsApp message. The Cruz bill threatens personal sanctions against Nigerian officials who enforce Sharia blasphemy laws. CLAIR has launched as a formal legal challenge. If all three of these developments produce their maximum possible outcome simultaneously, a Supreme Court ruling striking down blasphemy death sentences, U.S. sanctions against named Nigerian officials, and CLAIR winning its first major constitutional case, do you believe that combination would be enough to fundamentally change how Sharia criminal law operates in the 12 northern states? Or is the political and institutional resistance to change deep enough that even all three together would be managed, diffused, and ultimately absorbed as every previous challenge has been? One answer, drop it below. If this analysis gave you clarity, share it with one person who needs to understand what is really happening in Nigeria. Like, subscribe, and I'll see you in the next one.